meeting with the police in the weeks before the G20 weekend, basically to understand what the rules would be in respect of the scope of peaceful protesting. At no time did either police force advise the CCLA or any other group of this regulation. Indeed, as their lawyer, I was dealing with their lawyers throughout the legal process in the days before the G20. At no time was I advised of this regulation.
The investigation that I'm reporting on today is the first of several public attempts to get to the bottom of exactly what happened here during the week of the summit, why it happened, and what can be done to ensure it never happens again. My investigation focused on the province's role in promoting what became known as the secret security regulation, a little known and widely misunderstood legal measure that was supposed to help the police keep the peace, but in my view wound up contributing to massive violations of civil rights. Some people in the ministry were rightly concerned about the optics of using wartime legislation, but others saw the regulation as mere technicality. So the decision was made not to publicize it. Instead, they quietly handed the police extravagant, sweeping powers under 71-year-old law. Powers that would almost certainly be illegal and unconstitutional under the Charter of Rights and Freedoms.
And one of the main tenets of the rule of law is that the police will not overreact. The police will only detain people if they have reasonable and probable grounds that they have committed an offense. Our Supreme Court has been very, very clear in that regard, that these kinds of restraints are necessary on the police services, otherwise we will end up to be a police state. And that kind of excessive and arbitrary power which the police exercised on that occasion is shocking and appalling in this day and age. And what is more shocking is that no one has come to the fore to be accountable for this crucial undermining of the rule of law.
Reviving this dormant piece of legislation, coupled with the adoption of the regulation, created a legal landscape where people were detained by the police and compelled to identify themselves, answer questions, and submit to warrantless searches, even if they simply wanted to walk away.
But we also know that there may be a small number of people who use that crowd, the anonymity of a crowd, to throw rocks and to break windows and to start fires, and will attempt to incite violent confrontation with the police. They had an idea that this was going to happen. In fact, that was the undertaking they gave to the judge on the injunction. We need the sonic cannon because there's going to be this rogue element. Even if it was unexpected, it doesn't give you the right to arrest hundreds of innocent people.
You're within 5 meters of this wall, so please turn off your video camera. Okay. Public Works Act states that, so please.
Because we're
show your identification of these officers.
5 meters from this wall. All right, we'll stop filming. But it's because obviously
your identification, please.
You can't do that. There's no legal basis for the police to do that, unless, of course, they're relying on the Public Works Protection Act, which is wartime legislation. You know, the government, the ministry had its website. The City of Toronto had a website. The Integrated Security Unit had websites. Had ads in the paper warning about street closures, things that were going to happen. Was there any at one point mention that the police had a right, according to a 1939 law, to arbitrarily detain citizens kilometers away from the fence, to search their belongings, to force them to identify themselves? No, at any time there was not, and that was a conscious, premeditated decision by the authorities. Apart from a coterie of senior officials in government and the Toronto Police Service, no one else was aware of the existence of this regulation or the fact that they would trigger what amounted to martial law in downtown Toronto.
We're at Queen's Park, the same place they came to get